One of the key documents in an estate plan is the power of attorney. This document is where you appoint a person to represent you or act on your behalf in the event you become incapacitated and need assistance with your financial matters. This agent has the great responsibility of making sure that your bills are paid, that your assets are being utilized for your benefit, and that you're being taken care of. It is important to have a backup to the primary agent. And if you're not comfortable giving somebody an automatic power, we can do something called a springing power of attorney. This does have downsides, but let me tell you what it does. So, where an automatic power of attorney will give the agent that you appoint the automatic ability to act on your behalf. They could take it right to the bank. The springing power of attorney requires something to spring that document into action. And that often is a letter from a physician or some other third party that says you are, in fact, not capable of managing your financial matters. That will spring the power of attorney into action, at which point your agent should be able to act on your behalf. The upside is you're not giving any powers right away. The downside is if you really are in need of some financial help, there's the barrier of getting a doctor's appointment or managing the ways that you've said the agent needs to take in order to activate this power of attorney. So there's plus and minuses. Knowing that you can always cancel the power of attorney as long as you have capacity, appoint a new agent, take away or give additional powers. So just because we're preparing this document, appointing somebody automatically does not mean that you do not retain all the powers over your assets. In fact, the agent should never act until you've told them it's time to, or you have lost capacity. Now, what happens if we have this fantastic document? It outlines all the powers, and the banks refuse to let your agent use it. Now, this does happen from to time, and often I believe the banks are, looking out for either your interest or, quite frankly, theirs, and not wanting the document to be misused. Well, unfortunately, that can also create barriers at a time where we really, really, really need the agent to have authority over your finances. If possible, it's usually a good idea to bring the person who signed the document to the bank or financial institutions with you. That will help the bank see that that person either does have some level of capacity and they are in fact appointing you, or it will give the bank an understanding that the capacity of this individual is compromised. So again, this might create a time where there's not the ability to act over a person's assets with regard to certain assets. If you go to a different bank, the other bank might be able to give you access right away. So sometimes this is bank specific, sometimes it is specific to a branch. So even trying a different branch might be the best first case situation, right? Just drive down the street. If it's a big bank, oftentimes the teller will work with you where another teller might not. Ideally, if somebody has a relationship with their banker, usually this does help. So if you are somebody who goes into the bank knows you, they can see the decline in your capacity, and hopefully when your agent brings that document into them, you are taken care of, right? Your agent can step right in. Another good thing to do is perhaps bring this document to the bank ahead of time. While I don't love that, some banks are a little more difficult to work with. And so being able to bring this in while you do have capacity and letting them know that you don't want your agent to act until a letter is accompanying this or some other action is taken, that might be a way to head it off. Some banks don't like old documents. Personally, I think if you haven't changed it in the last 10 years, it's because it's solid. But if a bank argues with the fact it's older, again, just have them take it up to the legal department. If you had an attorney draft it, have them get involved. Worst case scenario, we're in court. But usually attorneys do everything we can do to have a bank accept this power of attorney from the get-go. Now, where banks get really hesitant are things that are done online, or it's clear that the person, might not have had capacity at the time, in which case it is fully appropriate for the bank to not allow the agent to act. If you are trying to get somebody to sign a power of attorney and they have lost capacity, that is 100% not appropriate. At that point, we do need to seek court approval for a conservatorship. It's really important to get these documents in before that time because the conservatorships are quite expensive and do take a bit of time to get approved through the court process. So ideally, we're creating these documents, people know about these documents, and there are number one agent and at least one successor, hopefully two successor agents. All of this should ensure an easier way for somebody to step into position for you and act over your finances if you are not able to act on your behalf. If you have questions about the power of attorney or any other estate planning documents and you live here in Oregon or Washington, feel free to contact me. Otherwise, call your local state bar or ask friends and family where they got their estate planning documents done.